Sehr geehrte Frau Botschafterin,
Ambassador, Commissioner, ladies and gentlemen, on behalf of the European Commission and the European Foundation for Fundamental Rights, I would like to wish you a warm welcome to the first dialogue on the rule of law. I want to welcome you on behalf of Jörg Wojan, who extends a warm welcome. He unfortunately couldn't be here today. Germany and the rule of law. Does this warrant a conference? We think so, especially because 77 years ago, Germany was founded after having inflicted so much injustice over Europe. Who would have thought that more than 70 years or several years ago, Germany would be a co-founder of the European Commission for Coal and Steel, and now is a member of a community where everybody works together despite having different opinions. The rule of law cannot be taken for granted. We must never forget that, especially here in the European House, which was erected on premises where the IG Farben trade union used to have an establishment. Ursula Hirschmann is one of the founding mothers, whose portrait is here in the foyer, and they gave us the task of making the rule of law a fundamental principle of the European Union. So we must not content ourselves to pointing the finger to individual member states. We need a broad-based debate in the entire EU, and we need this discussion on the rule of law in Germany. This is the purpose of the annual Rule of Law report, which was presented by the European Commission for the third time, and the German chapter of which we set out to discuss today. Before Commissioner Reynders will introduce the report, I want to say thank you also on behalf of my Brussels colleagues, Annegret Kempf among those, who is also here among the participants. We also want to thank the federal government. The first report on the rule of law fell into the Council presidency of Germany in 2020. On behalf of the many colleagues of the federal government, I want to thank Matthias Wehler, our national contact point in the Federal Foreign Office. Mr. Wehler, thank you very much for your contribution to this year's report, also in the preparation of this small conference. Also, we want to thank all those associations, non-governmental organizations, federal state governments, and attorney generals, some of whose representatives are a member of the panels. Without their substantial contributions and their exchange with us, we wouldn't have been able to devise this report. So we hope they will also make a contribution to the next report and will also play a part in implementing its recommendations. I'm quite sure that you will add to some aspects we might not have been able to get into in the warranted depth in the report. Also, I want to thank the colleagues from the European Fundamental Rights Agency and Ms. Heller. Thank you very much for making a contribution to the preparation of this conference. Waltraud, I want to thank you very much. I hope this thank you message shows you that the rule of law is based on a common effort, but also we need leadership to be successful. Commissioner Reynders.
our dialogue is your baby, and that it's the dossier you care about the most. Not because the other dossiers under your responsibility wouldn't be important, but because the rule of law is fundamental to anything else in your portfolio, and one might say anything the European Union is doing. We're very happy to have you here today. Commissioner Reynders, the floor is yours.
Sehr geehrte Damen und Herren, ladies and gentlemen, allow me to speak in English in this presentation, but thank you for joining us here today for a very special and important event, one of the very first rule of law dialogue with civil society and stakeholders. And I would like also to thank the Commission representation here in Germany and the EU Fundamental Rights Agency. You have seen some participation of the agency on the screen, for having organized this event together with the Commission's Directorate General for Justice. This is an opportunity for us to directly engage in an exchange with stakeholders at national level about the situation of the rule of law in Germany, and to don't speak all the time about the same usual suspects, and to engage a debate at the national level with the different member states. I'm very pleased to do that here in Germany. And let me start by recalling why we are here today. The rule of law is one of the founding values on which the European Union is based. It guarantees the effective application of union law and plays a crucial role for the functioning of the EU, ensuring that member states and their citizens can work together in a spirit of mutual trust. The rule of law is also central to make the European Union work well as an area of freedom, security, and justice. And it is essential for the effective functioning of our internal market, and of course for a business and investment-friendly environment. Unfortunately, in some member states, we can see that the rule of law is being seriously challenged. Therefore, the Commission developed a variety of instruments to address such challenges. In that regard, the rule of law report plays an important role. It is conceived as a yearly process in which the Commission assesses the situation of the rule of law in all the member states on an equal footing to prevent problems from emerging or deepening. And we are engaged now in a cycle with the publication every year of such a report. In the rule of law report, we look at 4 key areas: the independence, quality, and efficiency of justice systems, the anti-corruption framework, media pluralism and media freedom, and other institutional checks and balances. In July, we adopted the 3rd edition of the report. This new edition further deepens our assessments. For the first time, it includes specific recommendations to all the member states, including Germany, on the reforms needed to address the problems we identified. In the two first editions, we had very clear conclusions, but it will be maybe easier to take note of the precise recommendations. We will follow up on these recommendations, both at the political and at the technical level, and analyze how they are being addressed by the member states in the next report. Is the reason why I spoke about a cycle, because now it will be possible to verify year after year if there is a correct implementation of the recommendations and what are the needs to come back on the same issues or maybe to develop new recommendations. Today, and in the roundtable even tomorrow, we'll have the chance to discuss in more detail the key conclusions of this year's report and its country chapter on Germany. The report provides the Commission's own and independent assessment. It constitutes a basis for improvement and political dialogue. It is based on a rich variety. This includes the written input from the member states, as well as over 220 written contributions from a wide range of stakeholders, including civil society. We also conducted virtual country visits, during which we had over 500 meetings with national authorities, independent bodies, and stakeholders in the 27 member states. This input has been crucial for deepening our country-specific knowledge of relevant developments on the ground. In the preparation of the report, civil society organizations and independent authorities are essential because they are, in fact, allies of the Commission to ensure the protection of the rule of law on the ground. In general, the 3rd edition of the Rule of Law report shows that member states have made progress to address rule of law matters. However, it also shows that this progress has been uneven. and that there are causes for serious concern in a number of member states. As for the country chapter on Germany, let me just briefly highlight some key findings, in particular related to the recommendations. Overall, the report finds that the German justice system continues to function well. The level of perceived judicial independence is very high, and it performs overall efficiently. Efforts to improve the digitalization of the justice system have continued, and they would also be addressed in the new Pact for the Rule of Law. The recommendation on the justice system focuses on the resources of the judiciary. The Commission recommends to continue efforts to provide adequate resources for the justice system as part of the new Pact of the Rule of Law, including on the level of salaries for judges. This is a long-term challenge we have identified also in previous reports, and is also linked to the question of recruitment in the judiciary. Regarding the anti-corruption framework, Germany is in the process of updating its strategic framework. Germany has increased criminal sanctions for bribery of members of parliament. A number of reforms are also planned for the prevention of corruption, including to further enhance. One recommendation in this area is to proceed with plans to introduce a legislative footprint to allow for the monitoring and tracing of all interest representatives who seek to influence and contribute to specific legislative text. The other recommendation relates to an identified shortcoming in the preventive framework. We recommend to strengthen the existing rules on revolving doors by increasing consistency of rules, the transparency of authorizations for future employment of high-ranking public officials, and the length of cooling-off periods. Overall, Germany continues to enjoy a high level of media freedom and pluralism. Transparency of media ownership is ensured, and the media authorities enjoy a strong degree of independence. Authorities at both federal and London level are making efforts to increase the safety of journalists. But particularly when covering protests, incidents relating to physical aggression and online threats remain a serious concern. Journalist associations see room to improve the framework for access to information by journalists, and we have made a recommendation focusing on this issue. It asks to take forward the plan to create a legal basis for a right to information of the press vis-à-vis federal authorities. Finally, coming to the system of checks and balances, plans to improve the transparency and inclusiveness of lawmaking have been announced. The appointment procedure for the head of the Anti-Discrimination Agency has been reformed and a new head appointed, after the position had been only filled at interim for the past 4 years. However, civil society continues to experience challenges due to the uncertainty of rules related to their tax-exempt status. This is also the subject of the final recommendation to Germany. It asks to take forward the plan to adapt the tax-exempt status for non-profit organizations with a view to address these challenges. Let me underline that this is not a report for the library. It is meant to trigger reactions and dialogue. It is the follow-up to the report that matters. As with the previous report, the Commission will engage in inclusive debates both at European and at national level. I have seen the findings of the 2022 report to nourish discussions among a wide variety of institutions across Europe. At European level, the General Affairs Council holds a dialogue every 6 months on the rule of law situation in 5 member states, involving all 27 ministers of EU affairs. The next round will take place in December, and the General Affairs Council also holds a yearly debate on the general development of the rule of law in the European Union. Justice ministers participate in a similar 6-monthly debate. And so we have had the opportunity to start with the German presidency, such an exercise, and next year, with the Swedish presidency, will be at the end of the first round about the 27 member states. So it's quite useful. And with the justice ministers, I try to develop a specific element. We try to discuss, to give an example, about the independence of the prosecutor office, or we have discussed during the Czech presidency about the training of judges and other professionals about the rule of law, what kind of training to develop such a culture of the rule of law. But I'm also regularly discussing the report in the European Parliament, the plenary, or the committees. I was again in the last 2 days, 2 times, in the Libe committee or in the monitoring group to discuss this with the members of the European Parliament. At national level, engagement with parliaments is particularly important for the Commission. I have presented the first 2 editions of the annual report in many national parliaments. Now I'm continuing this practice based on the 3rd annual report. For example, at the end of September, I discussed the report in the Spanish Parliament, and tomorrow I will discuss it with both in the Bundestag and the Bundesrat. But we need to go beyond the institutions. If we want to build a solid rule of law culture, we need a broader involvement of society in the debate on the rule of law. This is why we have organized this event, together with you, key actors, civil society. It is important for us to strengthen your involvement and together have a genuine dialogue on the basis of our annual report. Today's public event aims to open a discussion and give a variety of actors, including the public, an opportunity to exchange on the rule of law report. And then tomorrow, in a smaller and more intimate roundtable format, we will be able to go more in depth. This dialogue is a crucial opportunity for us to listen to civil society's views, to bring together different stakeholders and authorities, and to see how they can best work together to follow up to the report, including, of course, the recommendations. As I mentioned, today's event is only the 2nd ever of this kind. We organized another such dialogue even in Belgium for Belgian civil society just earlier this week in form of a roundtable. Based on this first experience, we then want to expand this concept progressively to more member states. And to give you just an example, for the first time in the 3rd edition of the Rule of Law report, we have added a sentence explaining the level of implementation of all the decisions of the European Court of Human Rights. And I received remarks from civil society organizations, why not a remark also and an assessment about the enforcement of the final national decisions of justice. It will be maybe the case in the next editions. And based on this first experience, we want to expand this concept progressively to more member states. So we'll organize the same kind of meeting in different capitals. It's important to make the best use of this report and the wealth of knowledge it provides us to encourage concrete improvement and progress on the ground. The discussions today are an excellent example of this. It can foster and promote a rule of law culture throughout the European Union, and this can be a new, important pillar of our response to the emerging challenges to the rule of law that we have seen over the past few years. And now I'm looking forward also to hearing your views of the civil society organizations, of course, about the rule of law report. I will hear also the views of the German government, of the German parliament, and of course for a more broader audience. I want just to add that if we are doing that, it's of course to protect and to promote the rule of law in the entire European Union. but also to show that we are doing, as I said sometimes, we are doing the job at home. If we want to be credible outside of Europe when we are speaking to the candidate countries or to the external world about the rule of law, it's important to show that we are delivering also at home. And certainly after the Russian aggression in Ukraine, when we ask to Russia to have a full respect for international rules, like the sovereignty of one country or the territorial integrity of one country, it's very important that we are showing that we continue to do the job at home and to protect and promote the rule of law in the EU. So thank you again for your participation, and I'm hoping that after this event, it will be possible for many of you to organize the same kind of debate, maybe dedicated to one or another recommendation of our report, because I said we are now engaged in a cycle, and I count on you not only, and thanks for that, for the preparation of the rule of law report, but also for the follow-up and for a real intense discussion in the society to develop again a culture of the rule of law. Thank you very much.
Commissioner, thank you. We'll see you later here back on the stage at the end of the conference. It was very inspiring, thank you. Good keynote because it was brief but still substantial, and you've stimulated further debate beyond this event. And I would like to invite anyone who has a plan, not perhaps now but later, to host a similar event here, a small one, a workshop, whatever, to contact us, because this is the European House, not the European Commission House. So it's your house basically, and we're really happy if you come to us and you want to use these rooms for these debates. Now, we would like to hear what the German government is saying about the report in response to your speech. Ambassador, I understand you speak English today, which is fine for us. And the Foreign Office is basically in the lead for the rule of law dialogue. And so you're coordinating the position in the government. So you're entitled to speak on behalf of the German government. Very curious to hear what you have to say. Many thanks.
Thank you very much, Nikolaus, for the warm welcome and your hospitality, and for this initiative, for this event. It's, I think, it's a fantastic way to enlarge the spectrum and the stage. Dear Commissioner Reynders, first of all, thanks to you very much on behalf of my ministry, but I think I can say that also for the German government as a whole, for your commitment to a good cause, indeed the best cause. With your tireless commitment to the rule of law and to shaping a vibrant culture of the rule of law, you are strengthening, as you said in other words, the very foundation on which our European house is built. Without the rule of law, fundamental rights cannot be protected. Without a common understanding of the rule of law, a community based on this principle cannot function or exist in the long run. In this year's report, you pointed out how Russia's unprovoked and unjustified military aggression against Ukraine constitutes a direct challenge to EU values and the rules-based international order. We couldn't agree more. This is a matter of principle, as well as of very concrete relevance for European security. Disinformation campaigns and cyber attacks by hostile foreign powers aim at weakening support for Ukraine in a very concrete way. But they also aim at undermining and destabilizing European democracy as such. Why? Because every autocrat, at the end of the day, quite rightly, feels threatened by the freedom of expression and by an independent judiciary in which dissenters can assert their fundamental rights. Safeguarding our principles under these circumstances is therefore all the more important. The more effectively the rule of law is applied, the more resilient our democracies are against internal and external threats. The federal government therefore strongly welcomes initiatives to continuously develop the toolbox, the European toolbox in this field. The conditionality regulation, for example, which is now very much at the top of the agenda, was a project that we pushed very much forward during our last Council presidency. When necessary, we are convinced that sanctioning instruments need to be applied, but ideally, problems are solved long before it needs to come to that. In our community of values, we believe we can all learn from each other, from our different experiences, and this is why during our presidency we also worked very hard to establish the new rule of law dialogue in the Council. And we consider this instrument a leap in quality in this field. On the member states' side, the rule of law dialogue requires a willingness to address and openly discuss one's own possible shortcomings, which in particular in the beginning could not necessarily be taken for granted. But also the Commission bears great responsibility. I hear from my colleagues how thorough your staff conducts discussions with different parties and institutions in order to fully understand a situation on the ground. And we are convinced that this is the prerequisite for coming to an evaluation that also by the addressee is perceived as well-founded and fair and therefore much appreciated. Thank you very much. We are certainly very happy to hear that the Commission once again issued a very friendly view on the state of the rule of law in Germany, but nobody is perfect. Improvements are always possible, and the newly introduced recommendations are a welcome basis for this. And while we are the coordinating ministry, work has only begun in the respective relevant ministries, so I'm not going to go into the details of the recommendations. And I'm sure what is being discussed here today and tomorrow will also feed into that discussion, and that is the whole purpose of the exercise, I would say. But the German government, and Chancellor Kohl affirmed this in his speech in Prague, is committed to keep a close political eye on the implementation of these recommendations. So be assured we will do our homework. We also welcome the fact that you see these recommendations as part of the preventive character of the report and seek their implementation through dialogue. This is why we do not feel criticized, but encouraged. Encouraged to discuss ways to improve things, encouraged to explain why things might be difficult, but also encouraged to ask for advice. As EU citizens, we are entitled to civil rights everywhere in Europe. As EU member states, we must be able to rely and trust each other. And every attempt to further this, to strengthen a true rule of law culture in Europe, is therefore very much worthwhile. That's why we are deeply committed to the exercise, and we will remain to be so. You have all our support, Commissioner. You can count on us. Thank you very much.
Vielen Dank, Botschafterin. Very encouraging words, I'd say. Now, jetzt haben wir unser Podium.
Now, we do have our panel discussion, and I would like to start off by welcoming Dr. Zangi. She will be our facilitator. She's an attorney at law at Bedecker, Zen and Gas in Berlin, and she's also in the Constitutional Law Committee of the German Bar Association, and she's part of the Committee on Anti-SLAPP legislation that has to deal with journalists. So I would like to kindly ask you to take a seat. Yes, I have to take a seat. Thank you for that. And will you present the other panelists, please? Okay, so I'll give you the floor. Yes, thank you very much. Very kind. Ladies and gentlemen, I would like to welcome you on our exchange on the Rule of Law Report 2022, on the state of the rule of law here in Germany, or the rule of law situation here in Germany for that matter. And I would like the panelists to take their seat up here. Thank you. Now, the representation of the European Commission really managed to set together a very interesting and very diverse panel representing the justice system, the civil society, and also the media and press landscape here in Germany. What we would like to do today is to discuss with you the rule of law situation in Germany. Commissioner Reynders just mentioned the war on our European continent. where we are surrounded by neighbors and people who are, well, bidding farewell, if you like, to binding and fundamental values of the European Union and of Europe in general. Can we really point our fingers at others and state with a clear conscience that there is no violation of the rule of law here in Germany? Are our guarantees and checks and balances good enough to really guarantee a resilience of our rule of law? I'm looking forward to an answer to that question and also answers to questions you may have. And I'd like to briefly present our panelists. Up here, we have Andreas Brüller. He is a member of the board of the German Association of Judges, which is the biggest association of judges and prosecutors here in Germany. He has been a member of the justice system since 2003, looking back at a long career as a prosecutor and then later as a judge in different courts in Baden-Württemberg. Since 2019, he is the director of the administrative court in Bensheim. Then we have Anna Maja Mertens. She's a political scientist by training with a focus on European policy, and she especially looks at the structural conditions of political decision-taking. Since 2014, she is the managing director of Transparency International Germany. Transparency International Germany initiates and asks for coalitions from the business, the civil society, and policymakers to fight corruption. Thank you for being here. Last but not least, we have Mr. Christian Mehr. He looks back at long years of experience as an editor and free journalist for German and Swiss media, Deutsche Zeitung, Frankfurter Rundschau, FAZ, Der Freitag. Since 2008, he works at the German Institute for Development Policy, and since 2012, he is the managing director for Reporter ohne Grenzen, Reporters Without Borders, a non-governmental organization which fights for the freedom of the press and against censorship. Warm welcome to you as well. Commissioner Reynders mentioned the Rule of Law Report 2022 and also summed up the main points. I think it would be too long to really delve into the detail of this 40-page report. Therefore, I suggest we look at three main aspects of the report and discuss these aspects. And I'd like to kindly ask you for your expertise on these aspects. Firstly, the independence of the justice system. Secondly, transparency and anti-corruption measures. And then thirdly, freedom of opinion and pluralism of opinion here in Germany. And in order to do so, I would like to approach this group of topics in 3 steps. We've heard an evaluation of the report. We may have come up with our own findings and insights. And I would also like to discuss with you, the audience, some recommendations on the implementation of these recommendations. And perhaps we can also dare to look to the future and mention a few aspects that may not have been explicitly mentioned in the report. Things that you would like to deal with in the future. Let's start with the independence of the justice system. My question to you, Mr. Brüller, how do you see and understand the report on Germany, on the German justice system? It's been considered to be very independent, and for its major part, for its greater part, it is really efficient. I think some of my attorney and lawyer colleagues would look at this differently, especially when in urgent proceedings they are waiting for 1 year for a decision. So what's your take on that? Well, yeah, nobody is perfect. That's what we heard, and you're absolutely right. It's necessary to have this type of conference. Mr. von Peter, you said we shouldn't take this for granted. It is a necessity, and we found it very appreciative on behalf of the European Commission that they expressed in their rule of law report that it's absolutely necessary to look at the independence of the justice system and fit it with the appropriate resources to really deal with these urgent lawsuits and proceedings in an appropriate manner. We can be even faster if we have the right resources, and that includes an appropriate remuneration. It's not about earning more money, though. We are representing a great number of judges and prosecutors, but what's more important is that the 8 judges of the Constitutional Court in the Second Senate have mentioned several times that the remuneration is not appropriate. It does not represent the status of the third power, if you like. It's very important, especially when we look at summary proceedings and class actions. Look at the diesel proceedings, for instance, where we need the best lawyers, really, but others prefer to be, well, we need the best judges, but others prefer to be lawyers because they earn more money. Now, we really welcome the fact that you've made very concrete recommendations. That's very good for us and also for the rule of law. And we really hope that the federal government and also the state governments follow these recommendations, unlike they do with our recommendations, I have to say. Sometimes we have to, well, exert gentle pressure so that they do this. Perhaps the European Commission has more weight and these concrete recommendations have more clout. One concrete recommendation was that the Ministry of Justice should no longer give clear instructions to the prosecutors. Perhaps the media can help here in that they report about this. That would be an option, and therefore I'm also happy that media work is part of the rule of law report. The German Association of Judges would like to create facts to also make a difference. At the same time, we want to be very transparent and make sure that the justice system has the suitable resources also in the future. And with the pact on the rule of law, you mentioned a very important principle that should not only be reduced to be a mere digital pact, but really a comprehensive program as has been described in the German coalition agreement. Well, thank you very much for this first evaluation of the report. Turning to you, Ms. Mertens, from the perspective of the prevention of corruption and transparency, are there things that you find striking in the report? I found it remarkable that the financial damage in 2020 caused by corruption in comparison to 2019 has increased considerably, namely by 72.3% to 81.2 million euros. What about these figures? What do they mean in very concrete terms? Is Germany now more corrupt? And if so, in which areas are you seeing trends here? Thank you very much for the question and also for having invited me, Ambassador Commissioner Reynders. Thank you so much for having initiated this process, and it's absolutely valuable that the civil society is being involved. And I also thank you for focusing on the implementation. And if you allow me to do so, I would like to forge a bridge between Mr. Briller and myself, because independence of the justice system is also something that we find important. Being independent of instructions is of course very important, but resources is also a crucial point. There is barely any report by Transparency National that doesn't conclude without pointing to resources and a lack of resources. But of course, implementation is very important, and this is why we work with prosecutors, the law enforcement authorities, judges, and so on, where we constantly ask ourselves, these new laws that have been adopted in the context of anti anti-corruption, do they really work well? Are they efficient? It's not enough to have these laws, but they have to be implemented and put into practice. And here on a regular basis, we're asking for feedback from the law enforcement authorities to see how well that works. Now, you've mentioned these figures, and we constantly have to remind you of looking at these figures with caution, because sometimes growing figures can be good news, meaning that you detect more anti-corruption or more corruptive exercises and more corruptive acts. Often we speak to corporations and companies and they say, what wonderful work you do, but we don't find your work relevant because we don't have any cases. And sometimes they say, you have a mistake in your reporting system because these cases do exist. It's simply an undetected matter. So I wouldn't necessarily say that corruption has increased, or in other words, we don't exactly know, but regulation is progressing, and that's something that we welcome about the report. Many important areas have been addressed. For instance, the area of the integrity of political decision-making, lobbying, and we're saying we have these transparency registers here in Germany ever since the beginning of this year, but the derogations, the exceptions are so big regarding stakeholders being trade unions or church organizations, so that for the rest, their morals is simply disappearing. They no longer want to register. And we really welcome the fact that the independence of the justice system has been mentioned separately. And one last point, because I spoke to my colleague from Reporters Without Borders, who said, well, we are holding our breath because of geopolitical things that are taking place. I mean, we are analyzing 110 countries, as a matter of fact, and when we speak about the rule of law, we can be very proud of Germany and Europe. Nevertheless, there are countries that we have to look at much closer.
Exactly, but today we're focusing on Germany after all, even if we've learned that we are supposed to be somewhat better off. The figures were quite interesting, but if I understood you correctly, if you were to be cynical, we used to be just as corrupt, and there was some examination being done in the meantime, or some investigation, but the corruption provisions or the possibilities for leading investigations make quite something possible. Mr. Mier, how about pluralism and transparency of the media in Germany? In your point of view, is the report congruent with your own perception? Yes, thank you very much, and thank you very much for making this format possible. Also, Commissioner Reynders, you opened up the international perspective, and you said how important it is to spearhead activities in the field of the rule of law at home if you want to lead by a good example. You want to make the dirt in front of your front door visible, if I may say that. So I think this is a very good impetus that you provided, which we welcome. But before I answer this question you asked, maybe this is an encouragement to make something better, something you can improve in terms of methodology. Also, the same holds true for the future-oriented report. Something that's in the report is a beautiful description of the problem. It's very accurate, but in some cases we need to name responsibilities. Who's responsible for what? And then to answer your question, your characterization was rather accurate in terms of the pluralism of the media in Germany. In some cases, especially when it comes to regulatory issues in the media sphere, the characteristics of the German federal system is sometimes not taken into consideration when dealing with the media. I want to give you 2 examples. Well, I would agree that regulatory bodies per se are relatively independent and transparent, but you need to distinguish between the broadcasting agencies under public law and the federal state-owned broadcasting agencies, because those state-owned agencies publish annual reports, but they cannot always be compared. And this is also a dilemma of not being close to the public level, because public broadcasting is subject to direct control by policymakers because they have members in certain bodies. So there's a legal oversight, but no technical oversight. So this is something that could be included as a deficit in the next report, or maybe you could include it as a description of the problem. Secondly, you mentioned the state treaty for the media, which is an accurate description, but especially if we look at the Digital Services Act, if we look at the European level, if we look at media regulation, you might want to ask the question of whether this state treaty for the media doesn't make the world even more complicated than it has to be, especially when it comes to intermediary regulation, and whether this could be something that should fall in the remit of federal state legislation. And maybe to build a bridge to what Mr. Brilla said, independency of the justice is also very important from the point of view of the press, especially if we look at Russia and other authoritarian countries. Especially independence of the justice is important when it comes to defending freedom of the press worldwide. If we look at the international criminal law, it's of utmost importance in order to be able to prosecute enemies of the freedom of the press in Germany as well. But being dependent from the justice system, it becomes a political issue whether procedures in Saudi Arabia can be waged here in Germany. So establishing a connection between freedom of the press and independency of the justice system could be established. Thank you very much. I would like to address the concrete recommendations addressed to Germany that are mentioned in the report. There's a recommendation, just to mention a few points, to intensify its efforts in the context of the pact, the new pact for the rule of law, making resources for the justice system available, also when it comes to remuneration of judges. There are plans for the introduction of a footprint in the legislative process, and continuing this process is another point. Also monitoring and tracing all interest groups and their influence on the lawmaking process. Also, it is recommended to increase transparency when it comes to coherence regulations for a continued employment of official dignitaries and longer waiting periods. Also, when it comes to media law, a legal basis for right to information, to receive information from federal authorities was recommended, and also, another recommendation includes an adaptation for legal certainty in the context of tax exemption for non-for-profit organizations. So, maybe in this context, there's the recommendation of establishing a legal basis in the context of federal authorities. And in the last few days, I talked to media law specialists, and I was told that in Germany there's no legal foundation as opposed to federal authorities, but this claim or this eligibility to receive information from federal authorities is derived from Article 5, and I think this is also a point that's mentioned in the coalition treaty of the federal government. Is there room for improvement in this context? Yes, I could answer this question just by saying yes, but maybe I could specify what I mean and why this need exists. You rightly mentioned that this eligibility or can be derived from Article 5, but it is common practice that journalists are a common source of information, and if you look at Scandinavia, there's a whole different culture of dealing with transparency in everyday journalism. So there's the question of what kind of information I owe a journalist, and often there is no right to a certain information, but it's an interesting question. So there is a deficit in this context, and the federal system in Germany also comes into play in the context. We have a federal state press laws. They cannot always be transferred to federal authorities, so it would be extremely relevant for the journalists' practice if they could have a law to fall back on when wanting information off a federal authority. Well, I don't want to get into the nitty-gritty legal details, but it is my experience, and I would be interested in the participants' experience, that non-governmental organizations and other organizations often believe that by means of new legal provisions, new wide-reaching rights are created. In my experience from practice, this is not always the case. So due to an established jurisprudence, more legal certainty can be created. And if we look at third-party rights, we end up in a context where concrete provisions are missing, especially when it comes to weighing up whether I can release a certain information or whether I will infringe on certain individuals' rights. But you drew up a comparison to Scandinavia. Doesn't it always depend on the culture? We have a different culture in Germany in terms of data protection, privacy, and transparency. We don't want to disclose so much information in Germany. Don't you think that this cultural context also needs to be taken into consideration when it comes to freedom of the press and transparency? Of course, the international media landscape has become much more interconnected due to social media and new media, but can there be such an equal-footed comparison? Well, I don't think there's a contradiction. You don't always need a legal basis to create a new world. The world does not only become more colorful due to more colorful laws, but sometimes it seems an easy way out to use it as a pretext that a legal framework does not exist. So yes, it is a cultural question of how to deal with information, and the law for freedom of information in Germany is one of the weakest laws in the world when it comes to fees, when it comes to deadlines, but yes, it is a cultural question, and I think new laws are not a solution per se, but of course there can be also different opinions about a legal situation. Thank you very much. Maybe I can add something to this. A question, Ms. Mertens. When it comes to the recommendations on transparency in the lawmaking process, can you get into that? What is your opinion of these recommendations? And maybe we could add some controversy to the discussion. In my perception, when it comes to applications in public administration, that has not always created more transparency. There's a certain inclination in preferring different means of communication. Maybe transparency is not always the right decision, the right path. What's your point of view? Has this created a situation where many things have gone undocumented because a new EFG application had to be filed every time? Well, adding some controversy, maybe, I don't know if it's always a good idea, but we at Transparency International say transparency is not a purpose in itself. It is purposeful. Every time we call for transparency, we need to say what's the added value. Why do we want transparency? Of course, we need confidential spaces. We need a lot of confidentiality in the process, but also in lawmaking processes. And this has something to do with input and output legitimacy. On the one hand, the decisions made by lawmakers need to be politically legitimized. So there's a democratic involvement by different stakeholders of the people need to be taken into consideration. On the other hand, we need good legislation. We need efficient legislation that makes sense, of course. So that said, it's important to involve all stakeholders equally. In the last few years, what we've seen in Germany is that distrust grew in certain areas. The impression arises that some areas are involved to a higher degree in lawmaking than others. So therefore it's important to counter this distrust, creating more transparency and accountability. Why is a law the way it is? What's its background? What are the arguments that it's based on? So this is why we not only need a transparency register in Germany, it's the starting point, but if you will, the transparency register is the supply side. So, but what we are concerned with power, we are concerned with the demand side as well. And we are interested in learning what is required, what is requested, what is demanded by the political side. And of course, there's a question of how to put this into practice, but there are good examples at a European level to get into, well, to make transparent what meetings actually took place, how they came into being, maybe even exposed. So let me add something to these EFG processes. Maybe I can add that I'm from Finland originally, and I can tell you that too much transparency can also hurt. I'm also critical toward my first home country, but finding information on what's in the public interest, not being required to provide a reasoning, a rationale for this need is sometimes difficult. We have had some trouble in coming across information about what kind of scam software a ministry was aware of, so we didn't get the information we wanted, and we did something we usually don't do. We filed a lawsuit. It's not in our DNA usually. And what happened? Our counterpart at the ministry contracts KPMG. We have our 3 pro bono attorneys, and due to the fact that we were required to publish the information, and the information was that the government had to pay 300,000 euros in legal spendings, and the question is, how can we enforce the whole process? We are all very open for a pragmatic solution, but I think this proceeding is not a very pragmatic solution. Thank you very much. Now we get back to the independence of the justice system, and I want to get into making additional resources available to the justice system in order to increase its efficiency. We know that the digitization of the justice system is a big construction site. You mentioned that courthouses are affected by this, but I can tell you that also in law firms, lawyers have been required to use an electronic post box for quite a long time. I don't want to tell you anything about the technical status quo of this electronic post box. You would need an event of itself for this. But electronic communication with courthouses often happens unilaterally in an electronic way, but then everything is faxed back. The response is faxed back. So I don't know. Is it all about resources and making resources available, or is it also the willingness of certain actors in the justice system, or do we need a change of state of mind? Do we need to adjust to new communication paths? Do we need to move away from fax machines? And our Scandinavian colleagues don't even know what that is anymore. So does there need to be a culture change? Or is it only about financial resources? No, you're right. It's a question maybe also of tradition, of a state of mind. And the beginning is always difficult. The electronic lawyer post box wasn't a success story from the outset, and the justice system is not better necessarily. You know, in Sinsheim, at my small court, we are doing quite a good job dealing with electronic dossiers, but even at small courthouses, we need to face the fact that we need support. We can't deal with the situation that judges need to do all the technical adjustments themselves because the technology doesn't work. So making resources available is one thing, providing support and supporting resources is another. And you also mentioned an additional point. It's no good to hire an additional judge or an additional prosecutor if we have antiquated technology and equipment. This is an important point, and it has been my impression that, especially in the pandemic, we, were appreciative of additional technology, of new technology. And we see that the federal states have made a commitment. We've received additional equipment. It has not always worked perfectly, and some people have somewhat more trouble getting used to new technologies, or some people have more trouble doing menial jobs if it's not in their job description, but sometimes this can be good.
I would like to open up the discussion and involve you as the audience. If you have questions on the report, on the concrete recommendations, now this is your moment. And please wait to use the microphone, otherwise your question cannot be translated. Thank you. Hello, I'm Wilfried Fraser. I'm a blogger. And you're speaking about the rule of law. And what I'm talking about now is not only true for the Federal Republic of Germany, but also for the European Union. The Federal Republic of Germany and the European Union both want to be holding up the rule of law, but according to Article 5 of the Constitutional Court, we have to state the following. Since they don't prevent killing, they have people killed. So, my blog writes that the Central Council of Jews, did not contradict this publicly. I often spoke about people on their bicycles being killed, and on the 5th of April 2014 we had a Holocaust of cyclists in Germany. Every year in Germany, more than 200 cyclists are being killed. And for many, many, many years, no lorry is being fitted with the electronic turning assistant. Back then, in those days, you remember how they fitted cars with seat belts, which actually saved so many lives. But why are lorries not being fitted with these electronic devices to save cyclists' lives? Why don't you just, in an obligatory way, oblige all transport and forward companies to fit their lorries? That is my contribution to the rule of law in Germany. Yes, thank you very much for showing an interest in our event. I did not interpret this as a question exactly, and we've certainly noted in the beginning that there are weaknesses also in German rule of law. I find it a welcoming aspect that you report on this in your blog. That's also a sign of the freedom of expression. And we've taken note of your position here. Yes, I didn't want to ask a question. We are not with the Palestinians and Olaf Scholz here, but what you are doing is you're calling the killing of cyclists, and please shut up now, you're calling the killing of cyclists a Holocaust. And with that, you are actually trivializing the Holocaust, and you would be putting Germany in the same situation as Olaf Scholz and the Palestinians. And I kindly have to ask you to also give the floor to other members of the audience who would like to speak. Are there further requests for the floor on our discussion, especially the very concrete recommendations that we just discussed? It's not a concrete recommendation. I'm Jeanette Reich. I've been living in Berlin for 12 years. I've been a victim of the German justice system. I've been arrested with Stasi methods into trial awaiting my lawsuit. I am a victim. I've been criminalized. I've been deported. They've tried to extinguish my life, and we do have a huge problem here in Germany. I've been evicted of my flat. My flat has been searched, and all of these methodologies of mental warfare of the Stasi, the state security institution of the former GDR, are now being applied against me. My former husband worked for the Afghan secret service. Now, my life as it was up to now has been extinguished. I'm no longer a working woman. I am nobody now, but people are not leaving me alone. I'm afraid for my life because of all the things that happened, even physical attacks. I've seen things happen with other people. I'm completely derailed. I'm asking you for help. I've also done that internationally, and I've taken legal steps and asked for diplomatic solutions. I just want my life back, please. And you, as a judge of the German Association of Judges, you may be shaking your head. I also attended the World Congress on Psychiatry, where there was other judges shaking their head. I can prevail when it comes to an analytical discussion. I'm convinced of that I will always win an analytical argument. Now, I'm just asking you one thing. What was the shortest appeal that you ever held in your hand? A legal appeal that you held in your hand? Well, I've never looked at appeals. All I did was look at appeals in the upper regional court. But with revisions, I have to say, yes, they are rather short. They do occur every once in a while, and then the Supreme Courts have to look at whether everything went well in the first instance or in the instance of appeal. I think our justice system works very well, even though you may have a different perception. And when I look at these two comments, I mean, I have to admit that these are human destinies and your very individual fate, really. So we have to look at these individual cases because our justice system can mean an individual fate, and therefore it is important to have an efficient justice system, good media work, and to really lend transparency to those things that don't work well. Thank you very much. Did you want to react to that? No, I just wanted to reply again. I have the files of the State Security Institution, and I've looked at this very intensely, and I can only recommend you do the same. Since you're working on these issues, please look at the files from old times where people took advantage of because they know how things work, and they're just abusing these files to arrest people, to detain people without any reason. Yes, thank you very much for that recommendation. I think our requests for the floor leave it quite clear that a discussion on the rule of law cannot take place without really involving all people affected, all stakeholders, and really discussing the confidence we all have in our rule of law. However, at this point in time, looking at how much time we've left for our event, I would kindly ask you to request the floor only with questions and comments on the rule of law report. If this is not the case, I would like to move on and look at the implementation. Mr. Mir, you've already expressed additional recommendations. What about the state of implementation? What is your expectation, really, also with a view of the coalition agreement and what's been mentioned in there? Now, with a view to implementation and also what you mentioned, what you both mentioned, and perhaps also what we as Reporters Without Borders state if we publish our ranking and scoring of the freedom of the press, we are actually complaining at a very high level because we're still very privileged here. Now, when it comes to the implementation, we're seeing some rejections and oppositions because the coalition was forced actually to implement the right to information, and that was due to the resistance that we felt before. So I'm quite optimistic that we will have a good implementation of the right of information to the press. At least there are very concrete announcements of that. What I strongly hope, also with a view to the European level, this report, and it hasn't been mentioned yet, also touches upon the physical security and safety of journalists. And of course, to us, that's a matter of great concern. And here we hope that a European report, which makes mention of that, encourages authorities and institutions to look at the fundamental principles of behavior between police forces and journalists, where the Federal Ministry of Justice not always has played a very outstanding role. So we would like to swiftly see the introduction of new principles of behavior. I think it's a shame and it's actually embarrassing that a European report points to the deficits and violence against journalists. This is unacceptable that we have such an exponential growth of physical attacks against journalists. So we need new rules of behavior for this interaction between police forces, law enforcement officers and journalists. But this is not only a German phenomenon, we have to admit. So that would be my concrete expectation. And there are two more aspects that we feel strongly about and that are linked to the matter of federalism or the federal system here in Germany. I would like to link to what I said before. It's an interplay between EU and German media policy, which is indeed very complex, and that's something you have to bear in mind when it comes to implementation. And one last aspect, which also links to what you just said, namely the independence of the justice system. This means that you would have to give up a fundamental, perspective that you were holding so far regarding prosecutors. And I hope that, as we heard before, this is not something for the library and only something that admonishes, but that this is a clear indication and a clear instruction also with a view to international criticism that was voiced rightfully, I think, against Germany. So I'm looking forward whether this mechanism or the cycle, as you said, Commissioner, of rule of law reports becomes well established so that we can continue to observe whether the implementation of instructions to prosecutors will really take place. Ms. Mertens, what do you think about the implementations of the recommendations regarding transparency of legislation? What is the state of the art here? Well, thank you very much. As a matter of fact, we have stopped praising too early. I think we did that during the past legislative term when we looked at criminal law and the sanction of associations. That has not been implemented, and the same is true for the European Directive on Whistleblower Protection. I mean, that's long due, I have to say. What about the G20 presidency of Germany in 2017? There was a communiqué that we've really intensely worked on, where we looked at liability of corporations, and we haven't really implemented anything here. So the challenges are not shrinking, the political agenda is growing, and therefore we have to remain committed, especially when it comes to conflicts of interests and corruption in policy making. That is the very heart of our rule of law and our democracy. How are laws being drafted? We don't want to see conflicts of interests there. The areas that the report mentions are the right areas from our point of view. Also, transparency in the decision-taking of courts, transparency in administration, whistleblower protection, political corruption, political conflicts of interest. What I would like to see in future reports is money laundering. Money laundering, I think, is closely linked to corruption. Covert criminality works with burden sharing at international level, and Germany does play a role and offer certain havens here. So we would like to have this information available free of charge also to journalists. And to conclude, let me just briefly mention what we've just discussed briefly before this meeting, where I said everything that has been implemented in Germany came from the European Union. And then Madam Ambassador said, well, that's us, isn't it? And that's really heartwarming. This is something we have to bear in mind. Europe is us. That's a fantastic statement I will take home. And I'm very happy that you're also perceiving it that way. And that's the context against which we have to tackle these issues. Well, you mentioned, if I may come back to that, the right to information of journalists. You also mentioned physical safety of journalists, where in the course of the COVID crisis and other occasions we've seen these attacks on representatives of the media by law enforcement officers. What about the duty of the media and journalists? Now, especially against the backdrop of the problems that we're seeing in the media landscape, especially online media, you know, fake news and some type of journalism that I wouldn't call very serious, but is still very, well, let's say, close to policy making, not only in the United States, where I'm, of course, alluding to Fox News. We also have similar phenomena in Europe and in Germany. How do journalists deal with this duty to, well, report truthfully? Don't they have a lot of catching up to do here in order to strengthen the rule of law? Isn't that part of quality journalism? And also your claim to provide quality journalism. I personally have to say am sometimes involved in lawsuits, and then later on I see a report in the press about this, which simply doesn't reflect what I've seen myself, what I've experienced personally, and what I can read in the press. And then I would say, oh my God, if this is the way they report on certain events, I'm not sure whether I want this type of freedom of the press. I may be putting it bluntly, but I'm seeing this as a clear threat, and I'm missing these facts in the media landscape. What do we have to change? Because I think also this can be considered a contribution to the rule of law. What's your position on that? Do you have recommendations that could perhaps be taken up by a rule of law report? It also goes to you, Ms. Mertens, because it also covers your expertise. Well, yes, fake news, that's something I'm certainly rebuking, and I'm not willing to accept, because that's a term that Donald Trump has been coining, and I intentionally don't use that term. But there is this good old principle of journalism and the training of journalists, which is the duty of care of journalists, which means doing good research, asking all the parties involved where this is possible. And in journalism, just like in any other industry, there are deficits and shortcomings. I'm sure that is not a secret. Sometimes I'm also quite unhappy about how things are being reported on, but I think this duty of care is a very important principle in journalist training. On the other hand, we have to accept and see that the profession is constantly changing. It's more and more a freelance profession, being a journalist, which makes their professional and occupational life sometimes more difficult with regard to editing and also with questions of safety, because it's no longer the case that publishing houses are assuming the same protective screening function for freelance journalists as they would do for their full-time employed journalists. That's something we have to, well, admit and see. Now, basically, I don't think that reflects the experience in the population. The trust in the media in Germany is really not that low. At least that's my experience. Either the glass is half full or half empty. In the years of the COVID pandemic, I think the trust in media has even increased. Journalism, of course, is not perfect, and when we attend journalist conferences and congresses, we have the same information about a criticism of crisis and mistakes. We had the Network Research Annual Conference in Hamburg 3 weeks ago, where we heard that journalism is an industry that also has to deal with itself a lot because it's challenged quite a bit. But basically, the duty to care is a fundamental principle which is still being upheld in journalist training. And I think social media can even have a positive function because they challenge journalists in a different way and make them come down from their very high and superior position.
Thank you. Well, to draw an analogy of cleaning up your front door step, this holds true for journalists, but also for actors of civil society. Asking the question of what conflicts of interests exist in civil society, and we have learned that civil society can be misused because it's the space where the requirement of disclosure is not that strong. You know, you can use civil society as a facade, and criminals, who are often quick and effective, might abuse this. If we leave the facade as it is, and if we leave the facade opaque, intransparent, then we might end up having to deal with someone who doesn't have society's best interest at heart. So if we take this issue seriously, we need to be transparent ourselves. We are not the good guys per se. And in our surroundings, not only the good guys are present. Every day I'm dealing with multiple conflicts of interest. It's a weighing process, a constant weighing process. I'm a mother, I'm a volunteer, I'm a businesswoman at the same time. Nobody ever told me that it would be easy, but I need to be able to find a good way of dealing with it and implement it in the same way as we ask of others. Thank you. I want to get back to an independent justice system. All in all, the report has a rather positive tone when it comes to Germany. I'm asking myself, are our courts independent? And the report addresses this in terms of selection of judges. I think this is an aspect that we should take seriously in Germany, especially because independence of the justice is so important for the rule of law. And to be more specific, we are aware that selection of superior judges at the federal courts is subject to political influence, as we all know. Not only does the qualification or performance of individual candidates play a role, but also political proportions, political dealings play a part. So I'm asking myself, can our rule of law keep dealing with this situation, and how long? And doesn't this provide Hungary and Poland and the likes with an increasing number of arguments of approaching us, of not cleaning up our doorstep? So maybe this is a reason for self-reflection to be diplomatic. So what's your point of view? Well, we do have good structures, yes, but we need to make them more resilient to political attacks. It's a difficult balancing act. You know, the best judges should end up at the Supreme Courts, and there needs to be a balance between democratic legitimization. If there is an election, you have a winner and a loser. That's supposed to be like that, and not always the best person will win. Other than that, we have requirements in our constitution that stipulate that the best lawyers will end up in the highest courts. We talked about this issue at our annual conference, and it's difficult to come up with the best regulations. And we are happy that Commissioner Reynders will come to our conference in 2023, where we'll have the opportunity to discuss. The rule of law report is encouraging, and it encourages us to intensify our discussions about what we can improve. There was also an example. You know, if somebody wants to set out to become president of a court, we think that they should have worked at that court before. And, you know, in political turmoil, such regulations might be abolished, and this can't be too easy. We need structures that are resilient. We do have good structures. We do have presidential councils, which is the co-determination body of judges, and they have a quite a good concept of who should end up in these higher courts and who shouldn't. There are structures that are supposed to make sure that there is not such nepotism, but of course we need strong bodies, we need strong co-determination bodies. We don't want to make the decisions, but we want to make a contribution in optimizing the selection process that is based on merit, actually. Thank you. To close, maybe we can have an outlook, a look into the future. What are you missing in this report? Are there any areas or topics that you're missing? Mr. Mir, you somewhat alluded to it, but is there anything specific that you're missing out? That I could come up with 1 or 2 points that I'm missing, but I'm interested in hearing what you have to say, Mr. Mir. Well, I've mentioned one aspect. There could be a more differentiated dealing with the federal system in Germany. Secondly, there has been talk about the Russian war of aggression against Ukraine and Germany as a country that becomes increasingly important as an exile, providing shelter for journalists, and safety issues should be taken into consideration. It's important for the freedom of the press if a lot of refugee journalists want to go to Germany, because they deem Germany to be a country that provides good shelter for working in exile. And not only Russians are affected of this, we see that many journalists from all over want to come to Germany. But there are difficulties of obtaining a work visa. This might be something to address. And safety issues are important because there are repeated attacks on foreign journalists from Turkey, from Vietnam, to name but a few examples. So it might be a good idea to get into those topics. And a final point I'd like to make when it comes to independence of justice. If I repeat myself, you will excuse me for that. International criminal law is an important point, and prosecution of criminals under international law. This is becoming increasingly important in an increasingly authoritarian surroundings. You also alluded to it, Commissioner Reynders. So these are the areas that I attach greatest importance to, where something is still missing. I would like to add to something I've already wished for. In the context of Russia's war against Ukraine, we've been talking to our colleagues from Transparency International Ukraine. There was this, recently there was a Ukraine reconstruction conference in Berlin. And I'm really concerned, or we are really concerned, with the efficient implementation of sanctions against Russia. It's about making constitutional democracy resilient. At the moment, the federal system provides a hindrance for putting these sanctions into practice, and this needs to be coordinated with other countries. But the instruments we have at the moment are not sufficient enough. We have a transparency register, which is a bit, deficiency riddled. We need a register where I can enter a name of a company and I get the information of who owns this company. A lot of information is still missing in this register. A lot of information is faulty. So, for example, if the name has been entered in Cyrillic script, you can apply an easy trick to switch up to letters and no sanctions will apply. So we are developing mechanisms for journalists to deal with this, but there's no supervising body. Nobody monitors this. And this is why we say that money laundering is an important topic. How can we be successful to that? And we don't want to have this money parked here, and we need the instruments to ensure that this is not the case. Well, I'm not missing a whole lot in the report. In our point of view, implementation is the only thing that's still missing, and the specific approach in taking these steps further. I've already said that it's not an easy thing to do. We are discussing a lot. Our association also needs to talk with its members, needs to talk to other stakeholders. We might not always have the perfect solution for everything, but I think all essential points have been addressed, and we are happy that our impetus has also been incorporated into the report. Every time we come across points to address, we will make it known. And Commissioner Reynders said it. We will review the process in a few years, and we will double check whether the recommendations issued have actually been put into practice. Thank you very much. Well, if you said that you are not missing anything, that was a provocation to me as an attorney. So I would like to follow up on that. You mentioned the question of how resilient our state of rule of law is. And in Germany, people always have put great trust in our justice system, which is a great thing, obviously, but something I'm concerned about, especially or also when it comes to independence of the justice system, is that in recent decades we've been witnessing a certain trend that difficult political issues were taken to court repeatedly, which is not really what policymakers want. Think about marriage for all or inheritance tax, you know. So shouldn't courts be a bit more guarded when it comes to affecting their power? Of course, we trust the justice system very much, but isn't this the wrong path towards government of judges? What's your point of view of this development? Well, the rule of law means that everybody can have a decision reviewed by a court. And depending on the court order that you move in, or the process regulations, the rules of the process, you can proceed with legal proceedings. In the tradition of the American legal practices, you shouldn't lean back in order to do politics. Well, I can't do politics being applied by a small court, but even when it comes to superior courts, I don't think that a lot of dirt is being stirred up without need, without necessity. Every time we see a similarity and the legislator might not have come up with a law to regulate these issues, it is our job to get into those issues. So I don't share your view that we are on the path towards a government of judges or of the judicial. We basically react on what we are confronted with on a daily basis, and then it's our job to make a decision. So from the point of view of the Constitutional Court, maybe they might not have been required to do the job, but there was an applicant for the decision to be made, after all. Well, I think we could really hot up this issue somewhat more, but maybe let me take a look around. If there are any specific questions to what we have been discussing, maybe we can take the gentleman in the robe in front of you first. Mr. Meyer, Senate Chancellery Berlin. I have a question for two topic areas. There's a recommendation for the implementation of independence of the prosecutor or the prosecution. Well, we have a hierarchical system, traditionally so, and the danger might be that especially when the prosecution is no longer independent of politics, you know, that there will always be someone who's politically responsible. Would you need a legal prosecutor to ensure that the management level of the prosecution has someone who has not been appointed by politics? And do we need an appeal enforcement procedure? So would that be a judgification of the prosecution, so to speak? And my second question relates to money laundering in Germany. It has been my impression that especially this topic was, you know, sped up really, really greatly due to the Russian war against Ukraine. The transparency register will probably be revised, or there might be a new register on unclear assets or assets of unclear origin. So does this actually address the problem, or would Germany need a third sanction enforcement law? Thank you. Who would like to respond? Maybe I can respond to the first part of the question relating to prosecution's offices. There are lawsuit enforcement procedures, and if you're unhappy with the decision of the prosecution, you can use this procedure. It's also a matter of the jurisdiction. Prosecutions report to the Ministry of Justice, after all, so yes, the danger might be that such information is used in a political way. It only happens very rarely that this right to issue instructions is exerted by the ministry. And if this happens, the press will be quite alert, as I mentioned at the beginning, and they will decry this. Well, sometimes they might even support it, I don't know. But I don't see a problem in the right to issue instructions being lost. I think that this would not mean that the prosecution's offices would no longer be legitimized democratically. I think the regulations suffice to control or to issue control over individual prosecutors' offices. Well, I think we do need a third law, and we will see whether this will be successful. This is also an issue of European money laundering legislation. It's a very complex topic. Every time there is a change, a modification, an adjacent topic area will also be modified. The problems relate to different topic areas. It's about responsibilities. Who's responsible for what? This has to do with the federal system. You know, if we leave it open for grabs, nobody will feel responsible. It also has to do with digitization when we talk about monitoring these registers, because the question is how these registers are interlinked, how they are validated, what does machine readability mean. We don't need to start off using faxes again, but Let me give you an example of where the problems lie. You are all aware with the Climate Foundation of Mecklenburg-Western Pomerania, which no longer exists, and we did an exercise with the German Transparency Register. It's not very expensive, so we took a look at who has power of attorney at this foundation, and it's only one person, no federal state politician. Although we knew that Gazprom was involved, and we addressed them at the register because they had made a mistake. Then we addressed the Federal Administrative Agency and the Federal Ministry of Finance, and nobody thought they were responsible. And then we took to the public, and then something happened. But this is not how we want to proceed. We want to talk to each other. There's a lot to do still, but something is happening.
I assume that answered your question. Looking at my watch, there seems to be an additional comment, unfortunately off mic. We're very sorry for that. I think it's the gentleman again about the electronic turning systems for lorries. And while we understand his concern, we are not able to translate his comment. We're sorry for that, Commissioner. And I'm afraid I have to interrupt you. Is the comment of the facilitator. Yes, thank you very much. I would like to thank you for giving us an insight into your work and into your expertise. And now I would like to ask you, Commissioner, and she's switching to English.
Mr. Reynders, to join me on the stage. Thank you very much for having me here. Yeah. Thank you. Thank you. You followed the discussion, and so I was first maybe
take some notes.
Yeah, I want to give you first the opportunity if there is some remarks you want to make to the discussion we had, and then I will have my own questions what I want to ask you.
No, but first to thank the panelists, because it's not easy all the time to engage in such a conversation about different topics in the rule of law. But just some comments. The first one maybe about the first chapter of the report and the justice system. I want to insist on the fact that we don't want to organize the same justice systems in all the member states. It's not the goal. It's the responsibility of the member states. Due to the treaties, they organize their own system. But we want to be sure that the system is in full compliance with the treaty and with the Charter of Fundamental Rights. I mean an independent justice system, and so an access for you, for me, for all the citizens, to an independent, impartial judge. And saying that, I want just to insist on the fact that about the Constitutional Court, to give an example, because I've listened to the question about the way to select the members. We don't have Constitutional Court in all the member states. I've organized a meeting with the two presidents of the court in Luxembourg and in Strasbourg, and all the people involved in Constitutional Court, but we have had 23 participants, some Constitutional Court, one Constitutional Council, some Supreme Court doing the job, or other mechanisms. But the goal is to see in the global context if we have a real protection. And the last word is to say that you said that yourself, nobody is perfect. I'm using the same wording many times. What we ask is to make progress. And so it's true that there are room for maneuver and room for improvement in all the member states, also in Germany. But we act with other kind of instruments like infringement proceedings or stronger instruments now with the financial conditionality. If there is a regression, if we see a backsliding in one member state, so if we see a reform to go back, But for the rest, we try to improve all the time. And at the end, the main issue is to have the trust of the population, citizens, businesses, the member states between the member states, in the system. And because if you have a good trust in the system, it's become to be better. It's the reason why we try to organize this kind of discussion. And I want to add maybe also, because about the justice system, but about the journalists, about civil society organization, the trend for the moment, due to different problems that we have, is to insist on the independence. But of course, we will have to discuss if there are more and more independence in different fields, what is the responsibility? And of course, it's a discussion I'll try to have also with the Justice Minister when we discuss about the independence and appointment and the independence of the judge and prosecutors. If they are really independent, what kind of responsibility? And so that gave the opportunity to say that we are discussing about the disciplinary regime, but also about other kinds maybe of responsibility. It's the same for the journalists. We try to go as far as possible in the protection of their role in the society, but they are also responsible of what they are saying or what they are putting in a newspaper to be concrete. And in such a way, it's also a difficult discussion that we have. But about the journalists, I want just to add that we try to not only to put some elements in the report, because the report is about the rule of law, but you spoke about the protection. We have sent a recommendation to all the member states to take concrete measures to protect the journalists. Now we are working on the so-called SLAPs with a legislative act to try to protect not only journalists, human rights defenders too, and we will have a difficult debate with the Media Freedom Act. It's another kind of discussion to guarantee the pluralism and the independence of the media, but we will be open for a very large debate on that. And maybe one last comment, because I don't want to comment all the discussions, about the money laundering sanctions, because there is a link, I've seen that. About the sanctions, just 2 remarks. I'm in charge of the task force freeze and seize, so to see how it's possible to freeze assets of oligarchs and entities. We have more than 1,200 oligarchs on the list and other kinds of individuals, and then entities. Till now, it was possible to freeze 17.4 billion euros in Europe, 17.4. But 90% of that is due to 7 member states, including Germany, to be very open, right. More than 2 billion, so 2.2. But that means that in other member states, we don't have the same kind of situation. And to give just an example, in Hungary, they've frozen 3,000 euros. So it's not only the problem of the register in Germany, it's first of all to have a correct enforcement everywhere in Europe. And we are trying to do that. We have had 14 meetings of the task force, and we try to push pressure to exchange the best practices. But more than that, as my last comment about the sanctions, we try also to convince all the member states that it's needed to do more, and so to say, if there are some attempts to circumvent the sanctions, you explained to change from the Cyrillic to another kind of language, or to give an asset to a member of the family or another structure, it's very important that all the attempts to circumvent the sanctions become to be a criminal offense. And that will be possible not only to freeze, but to organize a confiscation. To that, I need unanimity in the Council. So I have the consent of the Parliament. I have now unanimity of the member states. We have had a legal process in Germany till now, but it's the end of the process. We have another parliamentary process in Poland, but I'm hoping and that in the next weeks, maybe, we will have the possibility to come with a project of a directive to implement that in the entire Europe. And so, of course, to try to say, if there are some attempts to escape the sanctions, we need to go to a tribunal and to have prosecution with a real sanction. That doesn't mean that we don't have new elements like a better register maybe about the different owners of different kind of assets. But that shows you that it's not enough to say that we are open to put into place sanctions. Like for all the decisions that we are taking, the most difficult part is the enforcement. And in the rule of law report, we try to explain that for many different kind of issues, and I want to describe, where it's needed for the Commission to ask a real implementation in the member states, and if it's not, to ask maybe to the Court of Justice to take a decision to force the member state to do that. So enforcement is true, it's a real issue, but not all the time with a new legislation. just also with the request to implement the existing legislation or the existing measures.
Thank you very much. You already mentioned the legislation proposal of the Commission concerning, for example, the Free Media Act or the Anti-SLAPP directive proposal, where I had a pleasure to work with the expert groups. So I was wondering, do you think that with this legislation proposal, aren't you fighting the symptoms than the cause? Because as I was looking at the aim of the both legislation proposal, I was thinking, would we need a SLAPP if we have really independent judges and judiciary system? Or, you know what I mean? Aren't they just like specific regulation where you see problems in some member states? I mean, you already mentioned that Hungary and Poland, we have problems. So I have the feeling that the Commission and the institution of the EU, and I do understand and appreciate the work a lot, but I'm just wondering whether that is the right way, just to fight the symptoms by the specific regulation proposal, and while we have a core problem concerning the judicial system.
No, but it's a combination of actions. If we have independent judges in all the different member states, we need to give to those judges the possibility to stop a procedure immediately at the beginning of the process. It will be the goal of the so-called SLAPP initiative. And so it's just an element of the procedure to say it's evident in all the member states that it's abnormal to have such a kind of lawsuit. It's possible to stop that immediately. But of course, we need also to be sure that there are independent judges in all the member states. It's not by coincidence that we have used different kinds of instruments to try to force an evolution in such a way to have an independent judiciary. And you mentioned, like myself, Hungary and Poland. But what are we using there? The rule of law report. But the rule of law report, like today, is very efficient if we have a real dialogue to improve the situation. If not, or it's not enough, we need to go to the Court of Justice, maybe to receive a decision. And in the country that I know best, I was doing 12 years Minister of Finance. And I want to say that the fact that you read a negative report on the rule of law is very impressive for the different governments. But the fact that it's possible to see a suspension of some funding coming from the EU, it's also impressive. I have the impression that the financial pressure is quite useful. And it's very strange, in the last weeks, and maybe months, but weeks, I've seen that with the discussions that we have about the recovery and resilience plan with Poland and Hungary, or with the procedure that we have introduced about the conditionality, we have received a huge set of proposals for reforms in the two countries. And we are engaged in a real discussion to see if it's possible to implement correctly that. So to have independent judges to fight better against corruption, the same. Because when you mention, is it the symptom? We need to work on the symptom, but to be concrete, we need also to continue to fight concretely against corruption. But is it needed to organize a criminal procedure for the people involved in corruption? Yes, but it's not a reason why we don't need to try to prevent corruption and to avoid that. But it's a fact, we need to work with a combination of initiatives. And it's not just to combat the symptom, because, you know, the murder is forbidden in all the member states, but there are murderers. And so you need to organize a sort of criminal procedure for the murders, but it's not a reason why you need to try to prevent the assassination of different kind of people in all our societies.
Thank you. You name it conditionality, and you said yeah, that's my favorite subject. So don't you think, you said the financial impression where you see that they are much more impressed when they, I mean, that's what I would expect. Don't you think that the initial reluctance of the European Commission in the decisive years between 2016 and 2020, where we had the infringement of the against the primary law, and specifically changing the judicial system in the countries you mentioned before, that the Commission lost the trust in its work as a guardian of the treaties, and where now you're trying with far-reaching proposal to fight the problem. But don't you think it's a bit late for this process which have begun?
But it would be too easy to say that I've been charged since 19, because you spoke about other situations. But more than that, in other capacities, when I was around the table of the Council, because I was a member of different formations in the Council during 40 different presidencies, so during 20 years. But I've tried 10 years ago to open a discussion about the constitutional change in Hungary. And the reaction around the table was not possible because it's not a discussion for the Council. In 2016, I've tried to put on the table the idea of a peer review between the member states about the rule of law. And slowly, with the support of Germany, but some other friends of the rule of law, slowly it was possible to move to what? A communication in 19, and I'm very proud to have had the possibility to publish the first report in 20. I mean, it was not a common sense to discuss about that. And when we refer to the financial pressure, let's be clear, if we have the opportunity now to discuss about some reforms in the recovery and resilience plan, is due to the Next Generation EU, a decision of end of 2020, and due to the pandemic. I'm not one to say that it's a positive effect of the pandemic, but due to the fact that we have a huge budget at the European level to organize the support for the recovery, it's possible to put in the plans some requests for reforms. And the conditionality, sorry, but it's a proposal of the Commission since 2018, and it was impossible to have an agreement in the Council on this till when? End of 2020, again, due to the pandemic and due to the fact that at the end of 2020, it was possible to discuss about Next Generation EU, a huge budget, and at the same moment, we have said we need to protect such a budget, and at the end, it was possible for the Council to agree on the conditionality mechanism. Unfortunately, with the progress, because we need the qualified majority in the Council, but you know maybe that the Commission proposed to organize the so-called reverse qualified majority. To be simple, it's easier to reach that than the actual system. And due to that, we have engaged the procedure. And why have we decided to do that this year? But because the regulation on the conditionality was challenged before the court by Hungary and Poland, and we have had the confirmation of the regulation by the court in February this year. And it's true that it was maybe possible to act before.
It's not suspending the procedure.
No, I know, but you know that the Commission has two possible ways to act when there's a real problem, or to go to the court, and we have a success. Huh? You know that we have had positive decisions also about Poland, interim measures sometimes, and also a fine of 1 million euro per day. And it's 1 year ago, so now we have more than 300 million that we request from Poland, and we have organized a setting off on the payments for more than 250 million euros till now. But the other way is to go to the Council and to reach a qualified majority. And in 2020, the European Council, the leaders in Europe, have asked to the Commission to wait the decision of the Court of Justice. Of course, you may try to go earlier to the Council and to ask a decision, but the Council asked to wait. And so it was the best solution to prepare, and we have prepared our file, and immediately after the decision of the court, we have introduced now the conditionality. But it's true that it's late, that takes some time to convince everybody. And if I may, it's one of the reasons of such a dialogue like today. Because we have a real support from the European Parliament on the rule of law. We have real support from the Court of Justice, from the European Court of Human Rights. We try to do our job at the Commission, and there are some criticism of that. But if we want to have the Council on board, we need to convince the national parliament and the national societies to take part in the discussion, because you know that for a national government, the most important pressure is coming from the national parliament and from the national public opinion, not from the European Parliament or maybe for the Commission.
Thank you very much for having this discussion and dialogue with us. I think we are at the end of our discussion, and I want to thank all the participants here and the European Commission representation here in Berlin.
Many thanks to all of you. Vielen Dank an Sie alle. Commissioner Reynders, it was very interesting to hear your comments on the debate. It was a very rich debate. War sehr, sehr reichhaltig, fand ich sehr erfrischend.
I found this indeed very refreshing, and I'm quite surprised about the different facets of the report. Also, thank you for your very precise questions. Thank you to you in the audience, also for this very lively discussion. All that's left for me to do is to wish you a wonderful evening, and hopefully you'll pay attention to the report next year and help us spread the news about rule of law in Germany. Thank you and goodbye.